On the calendar is People v. Lucas.
Good afternoon. Anders Nelson, Appellate Advocates, on behalf of the appellant Antwyne Lucas. I'd like to reserve 3 minutes for rebuttal, please.
Yes.
Defense counsel committed 2 serious errors at Mr. Lucas's trial, failing to make the jury aware of prior testimony casting doubt upon the complainant's all-important lineup identification, and consenting to the omission of a jury charge on the questionable reliability of cross-racial identification.
Are those mistakes impacted or affected by the defendant testifying and putting himself at the place?
No, Your Honor. This
Why?
is not a classic identification case, as Your Honor is noting. Mr. Lucas did not say that he was not present during the incident, during the robbery, as you would have in a normal identification case. But Mr. Lucas was saying that he was not the person that the complainant identified him to be. He was not the gunman who committed the robbery. So the
Does that
identification...
matter for purposes of the charge? Of the charge, not the, I'm sorry, the counts.
For
Does that matter
purposes
for
of...
purposes of the counts? Did any of the counts turn on who actually held the gun?
So the case turned on who actually held the gun. The people proceeded under 2 theories, but they primarily presented the appellant as Mr. Lucas as gunman theory.
But wasn't
And-
there also an accomplice liability theory?
Yes, yes.
So
That's
what do we make of that and the impact on the consent to omit the charge?
So the evidence was vastly different of culpability between the, if Mr. Lucas was identified as the gunman rather than the accomplice.
So different
Because that was
it
your
affects
defense,
accomplice
right?
liability?
But your defense, I thought, was, I didn't know what was happening, the defendant, I didn't know what was happening, this person I was with took a gun out and shot. Big difference if the victim identifies him as the shooter or as the other person, right?
Precisely,
Yeah.
yes. Yes, so that is the core of the case, and that's what the parties were arguing about. And if looking at the prosecution summation as a whole, the prosecutor says, well, he could have been an accomplice, but really he was the gunman because that's what the complainant said. And the gunman, of course, was the one who walked up to the complainant, put a gun to his side, said, give me your property, took the property, and punched the complainant. The other guy, according to the prosecutor in his summation, is merely standing around. So he says, Mr. Lucas was not this guy just standing around, he's the gunman. That's what the parties are fighting about throughout the entire case, and that's the primary issue before the jury.
Counsel, the argument we just had, there was a lot of back and forth on, do you have to know what's in the CJI instructions, right? You have to know what's in there, the instruction that's in there. There's no issue in this case that defense counsel knew this was in there.
Precisely, because it's clear from the record that the court handed out a physical copy, a paper copy of the charges that it was considering at the charge conference, which is a common practice, and it's the word CJI appears over and over. They're looking actually at the charges. When the court refers to this particular charge on cross-racial identifications, it says at the bottom of page 3, it's very clear that they're actually looking at this document. The footnote to that,
And then the court says you're not entitled to it.
yes, the court gives its reasoning. So this is also a different record than in Mr. Watkins' case. The court says there was no expert, and it says, so this wasn't an issue. But both of those rationales for not giving the charge are directly contradicted by the footnote to the CJI, which the parties had in front of them, and counsel should have been well aware of, which says an expert is not required.
So are you suggesting that he was aware of the charge and he didn't take the time to consider what its import would be?
My argument is that counsel, in not asking for the charge, failed to, he may have recognized that the charge, I mean, they certainly discussed it. He seemed to recognize that it was available. But he apparently did not recognize that the court's rationales for not wanting to give the charge, for saying it was out, were incorrect and were actually contradicted by the footnote to this.
But at the time, it's my understanding, and correct me, of course, but I thought the appellate divisions were upholding judges who declined to give the charge for those reasons.
Correct, which is why, I mean, yes, that's what the appellate division decision in Boone basically says, and in Dingle, and these other cases
So
that were.
when the judge says essentially this is the law, and he agrees, the council agrees, yeah, I'm not entitled to it, accepting the law at the time. So this seems to be a case where we really have to retroactively apply Boone in terms of being an ineffective not to ask, because you should have gotten it. Because you weren't clearly entitled to it at the time. In fact, I think the council's right that under the laws it was, they probably wouldn't have gotten it.
I would disagree that counsel was right, because as has been pointed out, leave had been granted in Boone, the case had been argued and
Oh,
submitted.
I understand that point.
So,
It's
so
the
counsel,
Boone.
so we have these cases like Turner, for instance, where Turner, this court acknowledged that there was maybe some contrary authority, but the standard that the court set forth is whether a reasonable defense attorney would have thought the argument not worth making, right? And that's the standard that should be applied here. Could an attorney.
Was there expert testimony in Boone?
In Boone, at the first trial? No, I do not believe so.
But we'd have to apply Boone. You'd have to say you should have seen Boone coming, right?
No, Your Honor.
So then-
Counsel should have read this footnote, should have looked at the cases,
But
right?
even with that footnote, the appellate divisions were still saying, yes, it's discretionary, and the judge doesn't have to give it to you for those reasons.
But if counsel had looked at those cases, right, had done the bare bones minimum of going onto Westlaw or LexisNexis and seeing if there's any history to those cases, it would have seen that in Boone itself, leave had been granted, it had been argued. Dingle, right?
You would have to anticipate Boone, is, I think, the point you're making.
No, counsel has to know that there's an argument that's viable, that's available for him to make, right? There's a viable argument for him to say, these decisions are not necessarily the law because the CJI is giving me that there's no expert required and that the only thing that has to be an issue, right? Counsel is not.
But what if he doesn't want to make that argument? What if he says, I'm not going to focus on ID, because I know my guy's going to get on the stand and say that he was there, so I'm going to go in another direction and talk about something different? He can't make that choice?
ID was the primary issue in this case. Counsel said, counsel
But the
asked for.
defendant placed himself there, so then it
But-
becomes a what happened, not a who did it.
No, Your Honor, in this case, counsel convinced the court, and the court agreed rather willingly that this was an identification case. It gave the one witness charge. This identification had so many problems with it. The identification of Mr. Lucas as the gunman, which was the critical issue, right? This is a 4-second robbery, after which the complainant can only describe 2 black men. And in the complainant's testimony, when he's saying, when they're asking, how light was it? You know, could you see? This was kind of dawn. He says, I could identify their ethnicity, right? There are clues throughout this record that the complainant, in fact, saw the race of the 2 individuals who approached him, and those were the only things he could distinguish. In fact, in his 911 call right after the incident, he says, 2 black men, that's all I can describe. The gunman, the complainant says throughout, was wearing a white shirt. Mr. Lucas was wearing a blue shirt, right? This is undisputed. There were so many issues with this identification. The complainant focused on the gun. He described it as black, flat and black, not a revolver, right? This is a 4-second robbery. So he has no time to perceive what is going on during this robbery. He says, oh, this other guy made me
But
feel.
that wasn't his defense, though. He decided to defend it otherwise. He decided to say that he was at the scene. So all of those might have been a legitimate defense if he had said, you got the wrong guy.
He did say you got the wrong guy because he said the complainant's testimony that he identified the gunman in a lineup was mistaken. That when the complainant allegedly looked at that lineup and said, that's the gunman, that was a mistaken identification, right? And so that's why this testimony by the detective, I'm sorry.
Go ahead, finish.
By the detective that the complainant wasn't too sure that he had identified the gunman in the lineup, which was never brought before the jury, was so meaningful and impactful.
But couldn't the jury have concluded that even if your client was not the gunman, that he nonetheless was a willing accomplice, as opposed to, I think he testified, he just, went along and did not anticipate that the robbery was going to take place. So wasn't there an alternative basis for liability, even if the identification of your client as the gunman had been rejected by the jury, which I assume is what the charge would go to?
Yes, yes, but it was vastly different quantity of, and quality of evidence, right? That Mr.
Your
Lucas
point, I
wasn't-
think, is what Judge Garcia articulated a minute ago, which is that if he was the gunman, then your client's defense could not be believed.
Correct, yes, exactly. So if he's the gunman, he is guilty, there is no question about that, right? But so that is why it's so important for
Why the
his-
identification matters to you.
why the identification matters, right? So when this court and other courts dealing with ineffectiveness have talked about, the fairness of a trial, right? That's what we're really looking at. We're looking at whether there was a reliable adversarial testing process here, whether the jury's truth-seeking function was facilitated by the presentation of the evidence. And the jury was told that this complainant said, that by the complainant, I sat in the lineup, I saw the gunman. They were told by the detective, he sat in the lineup, he saw the gunman, and that was Mr. Lucas. And they were never told that he said he wasn't sure if he was the gunman. I mean, it's the core, the most central issue in the case, and it certainly was devastating to his defense, as well as the failure to give this charge.
Counsel, to go back to something we were talking about earlier, where you said, Boone is up there, and there are these other signals. At what point in Boone's journey, or is it before, would you think that counsel has now the professional obligation to ask for the charge, in anticipation of the law perhaps changing?
I think leave being granted is certainly a signal that this court is considering changing the law or advancing the law, or at least giving more clarity to the law, right? But counsel here had everything he needed before him, because the CJI said, you don't need an expert, and the court said, well, there's no expert, so I'm not giving it. And the CJI said, well, these other courts have said it should be given if identification is an issue, and identification was an issue. The court agreed and said, this is an identification case. It said, that the identification is the primary disputed issue here, and it's what the parties were really contesting throughout.
Thank you.
Good afternoon. May it please the court, Tim Pizzoli for the people. Defendant's case did not support the cross-racial identification instruction under the law in the Second Department at the time of trial, nor would it support it under the law announced by this court in Boone. Additionally, a review of the record does not support defendant's claims of error and prejudice, but shows a competent trial attorney who provided defendant with meaningful representation.
Why wasn't he entitled to the charge?
Because, Your Honor, well, legally or factually?
Factually.
Factually, he wasn't entitled to it because this wasn't an identification issue in the sense of mistaken identity. The threshold issue here is how we look at the identification issue, because that will dictate what legal principles apply. The difference in identity issues was laid out by this court in People Against Agena. There, in the context of an identity Molyneux exception, where the defendant testified he was on scene but had not committed the acts he was accused of, this court held that the identity issue that was relevant was who did what, not whether defendant was on scene. And because defendant denied committing the acts, this court held that though there was no possibility of mistaken identity, but it was identity as far as who did what, and was still at issue, and then, so the Molyneux evidence was
Well,
properly admitted.
let's back up a little bit. So, and stop me at any point you disagree with me. The purpose of the cross-racial identification instruction is based on science that says people have, recipient witnesses have a difficulty identifying people of a different race.
Correct.
Okay. So here, the witness is of a different race than the two assailants,
Yeah, yes.
right?
Yeah.
So presumably, he might have difficulty identifying one or the other, right?
Potentially.
And so, well, that's what the
Right, yes,
instruction's
that's-
about,
yeah.
right? And the question here is, which one of them had the gun?
That is only part of the question,
Okay,
Your Honor.
but do you agree with the proposition that the defendant here has no defense if he had the gun?
I do, yes.
Okay, and he has a defense, he might not win it, but he has a defense if he doesn't have the gun.
He has a defense, but yes,
Okay.
but.
So then the ability to distinguish between which of two people of a different race has the gun, doesn't that depend on your ability to recognize the person of the different race?
It could, but it also,
But then why wouldn't you be entitled, not entitled legally, why wouldn't you be able to ask for that instruction?
you wouldn't be, well, because the identity issue that we have here is that after defendant testified, there was no longer a question about whether Father Roselli was robbed, whether defendant was present, whether a gun was used, whether Pack participated in the robbery, that the two men took the car.
Right, but we need to know which one of the two black men had the gun. It makes a material difference to the defense.
We don't need to know that, because the identification issue here is who did what, and the victim was saying that both men.
Let me back up a second. We need to know that because one way he doesn't have a defense at all, and the other way he has a potential defense.
But we need to know that it was defense that Pack robbed the victim and defendant did not. But the issue here is the credibility evaluation. It's not necessarily just the gun, it's a credibility evaluation.
One way you don't have to evaluate the credibility at all. That is, if he has no defense, you don't have to evaluate the credibility at all.
Well, that's true.
Right.
And so but where he does have a defense, it's still a credibility
Sure.
evaluation. You had two different versions of events. You had the victims and you had the
That's what the
defendants.
charge goes to, right? The charge goes to helping the jury understand some of the challenges in making cross-racial identifications, which will bear on how much you credit an identification, right?
But once defendant put himself on scene, it was no longer a mistaken identity. It was who did what, because the victim had said repeatedly,
Well, to the
both
chief's
men
point,
robbed me.
perhaps it still is relevant because it determines whether there is this defense available that I was not a willing participant or not. But let me ask you, if I can, about the other error that defense counsel raises. What reason could there have been not to cross Detective Morales with his prior inconsistent statement that the victim wasn't sure if the defendant was the gunman?
Well, I think there's two potential. I think in response to that testimony, the attorney cross-examined the detective and brought out that the victim had told him that the person in the white shirt was the gunman, and that on the defense case, he made clear that defendant was not the person in the white shirt. So I believe he maybe went that route instead. And then if counsel did cross-examine Detective Morales on whether he was certain, the victim was certain that defendant possessed the firearm, a simple redirect from the people could address the matter with simple questions like, how many people did the victim say did rob him? And was the defendant one of those people? How certain was the victim that both men participated in the robbery? And this would give the people a powerful last word on the matter and reinforce how certain the victim was that he was robbed by both men, and one of those men was the defendant. And as far as the law under the cross-racial identification at the time in the Second Department routinely upheld these convictions in the absence of the instruction because the reliability had not been put at issue. And
In the single witness, sorry, yours isn't a single witness case, never mind.
And the most reliable way to put that matter at issue under the case law was either through expert testimony of the reliability of identification or through cross-examination of the witness as to their background and experience, neither of which were present during defendant's trial. And it wasn't so much that the court just said there was no expert testimony here, so you're not getting it. He went on to say that the difference in race was not at issue during the trial. So he was saying that it wasn't at issue during the trial, so you wouldn't get this instruction. I know that the CJI is instructive on the issue, but the case law around in the Second Department at that time still bound the trial court, and to the extent a model instruction differs with binding precedent, it can't be ineffective for following the binding precedent over a model instruction. And counsel also says in the brief that we should ignore the 2011 cases, but the pre-2011 cases in the Second Department. But those were the cases that the post-2011 cases were citing and the law that they were applying. And as for the contention that proper trial preparation requires consideration of a pending leave grant, would require the counsel to predict the outcome of the pending case, considering a novel question of law. And it's not so much novel that that the cross-racial identification instruction was an issue, but which way this court would come out on the issue, because there were multiple
It
states.
was already set for re-argument, so
It was-
you know you split. So you got a 50-50 chance that it's going to come out favorably to the defendant.
That's correct, Your Honor. But then also the judge just said, well, you're not getting it. So at that point, if you think that the law, if you're
Well,
familiar with the case
doesn't
law.
counsel object anyway? Doesn't counsel all the time when a court holds against them on a request?
They
May I
can,
take an exception? Or the court may even say your exception is noted for the record
They-
and move on?
they do, and and
When
sometimes they
when you
don't.
don't raise it, you've lost potentially your appealable issue, no?
Potentially, but it's still, if he's familiar with the case law, he knows that he's not entitled to
So are you
it.
saying that although the charge was in the CJI as something that an attorney could request, because there was discretion for the court to deny the charge, defense doesn't have to ask for it no matter what?
I don't know about, I'm not saying it no matter what, but I'm saying in this case, it was not ineffective not to ask for it or not to push back on the trial judge, because the defendant.
Because of the credibility claim? The credibility?
No, that's the instruction claim.
No, because you were saying that he put himself there.
Yes,
So
that's
credi-
correct, Your Honor.
Okay.
So it becomes an issue of credibility, and that was the point of the people's summation, was basically that it was a credibility contest. The prosecutor said, I'm not saying it doesn't, what I'm saying is it doesn't matter if you believe the guy had the gun or even if Pack had the gun, because we've proven our case both ways, and that's on page A631. So it wasn't just a throwaway, hey, it was absolutely from the beginning of the case until the end of the case, the prosecution's theory of liability was a theory of accessorial liability. And I think the defendant's argument rests on the assumption that the cross-racial identification instruction applies to all identity issues, including non-misidentification issues like we have here, so long as the witness is of a different race than the
So
defendant.
does this court's decision in Boone make any difference to your position?
No, it doesn't, Your Honor, because once the defendant testified, it took the issue of misidentification.
So your view is that
away.
even post-Boone, there would not be a more robust ineffective assistance claim?
It may be more robust, but I don't think he would be ineffective. I think, I don't think it would be ineffective.
And that's because of your view about whether identification is really an issue or for some other reason?
Whether misidentification
Yes,
is
that's
the
what I
issue.
mean.
Yes. And all the people's evidence supported the theory that the people put forward from the very beginning, and defendant's argument.
You're, a charge that might allow the jury to view the evidence as perhaps not reasonable, providing a lack of reason, or, I'm sorry, establishing reasonable doubt that the witness may be wrong about who was holding the gun, and therefore perhaps deciding the defendant's version. You think that was not the kind of charge that defense counsel should have requested?
I don't think it would have helped the situation here, because it became about credibility, because it became that the defendant's story was not credible versus the victim's story, the defendant's story that
Well,
he-
yes, but but the point of that is the victim saying, this is the person who held the gun.
Right, and then,
Right,
but then
so
the
he's
defendant.
trying to suggest to the jury, or through the charge, perhaps suggesting to the jury, that the witness may absolutely believe that, but they may be mistaken,
But that also
which is a
discards.
different kind of credibility issue. It's not that you find the witness incredible, that they're not credible, it's just that they are mistaken.
But that only pays attention to defendant saying, I was not the one who had the gun. He then went on to say, I wrestled with Pack, who had the gun. I
Yes.
wrestled him off, and then I was forced at gunpoint into the car, and then I forced him to pull the car over. And then it also requires to ignore the facts of the the apprehension and the flight they're from, and the video that showed them in no apparent disharmony as they walked through
Well,
the
those all may
streets.
be wonderful points to make to the jury, right, about why they shouldn't believe his version, which is different from whether or not you should have the charge so that the jury can factor in about whether or not they should or shouldn't believe his version. The fact that the victim may be incorrect, believe it, but may be incorrect that defendant was holding the gun. Because if they believe that defendant wasn't holding the gun, or at least it's not there's reasonable doubt that defendant was holding the gun, maybe the rest of the story now looks a little bit more believable, let me put it that way.
I don't think I don't think the cross-racial identification instruction cures the issue in this case, and I don't think it would have done that here.
Yeah, I thought I understood your position at the very beginning, which I don't think you budged from, is that if this case were being tried today and counsel had asked for the cross-racial identification charge, he would not be entitled to get it.
He would not be, he would be under Boone just because he asked for it. But the facts of it would not be.
Oh, but you don't, but I thought even under Boone, you only get it when identification is at issue. I mean, you don't get it in a case where it's not.
Then, yes, then that's correct, Your Honor, yes, and I
I thought that was how
You're
you
right.
started your
Yeah,
argument,
and
actually, is that he's not entitled to the charge
You're
even
right.
today.
You're right. He would not be entitled to the charge. Factually, he would not be entitled to the charge today because he did not put misidentification at issue. It was not the issue that the jury was evaluating in determining the ultimate decision in this case of whether or not the defendant participated in the robbery of the priest, of the victim. Defendant's claims don't withstand scrutiny because his trial counsel properly assessed the facts of the case and presented a well-tailored defense with a valid litigation strategy, and because counsel's actions were not error and present no prejudice, if there are no further questions, the respondent respectfully asks that the judgment be affirmed.
Thank you.
Just getting back to this issue of, was this an identification case, and how did identification play in here, given that Mr. Lucas put himself on the scene? And identification is always a confluence of two things, or at least two things. It's a recognition of another person, but then they don't say, who do you recognize, and then stop at that. They say, where do you recognize them from? And in this case, they asked, specifically, the complainant was asked, which one was he, right? So it wasn't just that he said, I recognize him from being
So
there.
fair enough, but perhaps, once Boone was granted, that was not an obvious nuance. Is that possible?
Not under this record that we have here, when counsel said this is an ID case, asked for the, first he asked for the one witness charge, but then when the court said, I'll give the witness plus, he didn't object to that. So
Under the acting in concert charge, if a jury, and we presume the jury follows the charge, does it matter who was holding the gun? If the
No.
jury follows the judge's instruction on that, the CJI instruction?
no, the jury would have had to have found that Mr. Lucas shared Mr. Pack's intent, and that he, there's a long list, importuned, aided, et cetera.
So again, I guess I go back to the question that I asked in the earlier argument that troubles me, that we're going to call someone ineffective and mark them as ineffective for their entire career based on a trial strategy. Maybe, we don't know. Why isn't it better to just allow the defense attorney to come in and tell us what he or she was thinking? Maybe they wanted to focus on the accessorial liability, not the identification. They're the ones who are in the best position, viewing the jury, looking at the witnesses. I'm just a little loath to say that someone's ineffective, especially when Boone wasn't even decided yet.
This
And
court-
especially in a case like this, where he does place himself at the scene.
So the entire defense from beginning to end was, he was there, but he didn't do it. He didn't have the gun. So I don't see how it's strategic to not tell the jury and not cross-examine and impeach when the prosecution presents a case, he said he had the gun, and you have, in the hearing minutes, him saying, well, he wasn't sure that he
You're
had
still,
the gun.
you can still argue the identification factors. Here, we're talking about the cross-racial identification.
Right,
So,
so-
you know, you can still explore that, and they did explore that.
There would have been a particularly easy way to argue the cross-racial identification issue here, given that, number one, as I've already noted, there was this racialized kind of element to the description. It was two black men, and he said I could identify their ethnicity, right?
I'll give
He's-
you, it would have been better for them, but I'm just saying, does it rise to the level of being ineffective?
Yes, because the question is, can you identify a strategy? The people's, for the first time, standing up here saying maybe he would have gone with the white shirt. I believe that's pointing to the fact, one of the many, many issues here with the ID, that Mr. Lucas was wearing a white shirt, which was a key factor of the description. During the lineup, they said, well, it was covered with a sheet. That was in dispute. That would have played the testimony, the impeachment testimony that was not brought out would have played perfectly with that defense. It would have harmonized, as would the cross-racial identification charge. Counsel could have gotten up and said, look, you're going to hear that some people have more difficulty making an identification when someone is of a different race. And this idea that this was a credibility contest is just, it's not correct. It's not a correct way of looking at this case. Counsel said he was mistaken. He said, I'm not accusing him of lying. He's not accusing a priest of lying. That wouldn't make any sense. He's saying that he was mistaken, and when you have a 4-second robbery that's on video, that the guy gives allegedly the wrong shirt color, right? That he's focused on the gun, that he's saying, I'm so stressed out. He can't remember whether they have hats on or not. He can't remember anything but two black men, one wearing a white shirt. You have a perfect case, you have a perfect scenario to argue all these identification factors, say he mixed these two men up, right? He couldn't, he was limited in his ability to perceive the cross-race effect.
And all of that goes to the defense, not only that I didn't have the gun, but I am not a willing participant in this robbery. It's not just
Precisely.
about I didn't have the gun.
Precisely. Counsel had a great argument to
The
make.
fact of not having the gun is to support the actual defense, which is,
Yes,
I was not a willing participant.
the complainant has 4 seconds in which to perceive the actions of the other man, who, again, the prosecutor said just standing around during the incident, right? And said, that's not Mr. Lucas.
Thank you, counsel.
Thank you.